All right, so we've been going over some of the latest in the federal cases that were filed against Illinois' gun and magazine ban. And the latest is we've got a court date. April 12th is when there's going to be open arguments about the gun ban and magazine ban on Second Amendment grounds. Federal Judge Stephen McGlynn on Friday having all the parties from 4 different cases there with the defendants being the Illinois Attorney General on behalf of the Governor, J.B. Pritzker, and Illinois State Police Director, Brendan Kelly. Just some of the defendants here. But also what's interesting is there's some defendants from county-level cases where the county has been sued from enforcing this on a federal court case. So 4 different cases. The judge saying he did not want to be papered to death. So they're going to focus on the Second Amendment issues. And the judge saying that the National Shooting Sports Foundation lawsuit is going to be the lead in these 4 different cases in the Southern District. So the state of Illinois has until Thursday to reply to all 4 cases with also a list of all weapons and items. If you remember, earlier this month, the judge ordered the state to provide a list of all items, not just firearms that were banned. So the state's going to have to reply there. But I connected with the gun rights guru in Illinois. He calls himself Todd Vandermeide, contract lobbyist for National Rifle Association, retired. Also consulting with the Federal Firearms Licensees of Illinois case. He was able to tune in and listen to what the judge had to say, and he shared with us a bit of some of the commentary of what he takes away from what Judge Stephen McGlynn had to do on Friday when bringing all the various parties together on this.
I think this judge is being thorough and thoughtful, and he understands the implications of what we have, what's at stake in this case. I don't think he's going to be rushed, but I think he's going to give everybody the opportunity to get everything into the record to build the case, because he knows this is going up on appeal.
So Vandermeide also sharing that this is going to be a different approach. The different types of arguments being made. You've got, of course, the Second Amendment issue that's going to be debated and discussed. They're not going to delve into the Fifth Amendment issues or the 14th Amendment issues. They're just going to focus on the Second Amendment issues. But what about also the difference between the Federal Firearms Licensees of Illinois case and the other cases? The other cases are challenging the state's ban on guns and magazines. The Federal Firearms Licensees of Illinois are suing on the state's gun ban and parts ban. So a little bit of a distinction there. Vandermeide doesn't really see that as being a problem when it comes to the arguments that are ultimately going to be made here in federal court.
No, not really, because the way the judge has laid things out, that the state will have a single reply brief to us in terms of our motions for a preliminary injunction, that all 4 of the plaintiff cases get to submit a 15-page reply brief. By the rules of the district court, reply briefs in this case, or in this instance, you file your motion, the state replies, and then a further reply and rebuttal is disfavored. So the agreement that was worked out with the AG's office, because of the magnitude of this case, and it's really a case of first impressions within this court post New York, that we each get 15 pages to work on our arguments. And I think with the judge's admonishment not to be repetitive, and that he doesn't want to be papered to death, that I think that's going to give each of us the opportunity to work together to fashion a set of arguments that looks like a pie, to where, and I think the judge even urged the lawyers to work together on things so that, there are 4 cases. There's 15 pages apiece. That's 60 pages. If one argument is more important to one group than another, they can make that argument. Just try not to be repetitive about covering the same ground.
So again, Todd Vandermeide reacting a bit to all of these cases seeming to be consolidated, and the differences of the cases not necessarily going to impact the arguments here. They'll be able to make arguments about certain things, but each plaintiff group has 15 pages that they're set to reply to the state. So the state has to, number one, reply by Thursday to the motion for a preliminary injunction, and that's essentially a hold that could be put on the law from being enforced. So the state has to reply by Thursday to that particular motion, and then the state, March 16th, I believe, has to reply to the Second Amendment allegations. And that's something the state's going to have to hit on all of these issues that are being brought up by the plaintiffs' groups. And then April 12th, they're going to have a hearing in the Southern District of Illinois, East St. Louis. So put that on your calendar. April 12th. We'll definitely be down there to cover that and bring you the latest as it happens. But that's what's going on with the federal cases. But again, it's only about the Second Amendment issues. It's not about the Fifth Amendment issues or the 14th Amendment issues. And that's something that Vandermeide said his attorneys working with the federal firearms licensees of Illinois, they made an effort to try to do that as a way to clean things up and to streamline things.
Correct. That is something that our attorneys who brokered the stipulation agreement to try to do some case management on this got in there and asked the lawyer in the Langley case if he would mind holding off on those arguments because it's going to slow the case down. And it's another set of briefings that we don't have to deal with and argue with here. It's already complicated enough from the standpoint that you have the state as one defendant, then you have multiple states' attorneys in two of the cases being defendants. So you have this whole battery of lawyers that are supposed to be on one side. But as we heard, it looks like that may not be the case because you have the McHenry County State's Attorney who sued the AG on his own up in McHenry County. And that's been transferred to the federal district court up there. And they are a defendant in the Second Amendment Foundation case in this instance. So they're on both sides of this coin. And they said in the hearing today that they were not going to be able to reconcile that position with the state. So you're going to have that state's attorney filing against the state and not with them. There was at least one other state's attorney who talked about that they would possibly just stipulate to our briefs or sign on to our briefs or something like that. So, I mean, you gotta think that if you are a state's attorney in this part of the state, signing on with the state is just political suicide.
So again, Vandermeide noting that indeed you had several states' attorneys that were there as defendants. As defendants in the Southern District of Illinois, where they may have actually been opposed to the law back home. And that's really because, you know, if somebody sues, they want to make sure they cover their bases and they're not just suing the state, but they're also suing local jurisdictions from being able to enforce it. So that's how they get wrapped up in it. But one of them is the McHenry County State's Attorney, which in the Southern District is a defendant, but in the Northern District, the State's Attorney of McHenry County is actually a plaintiff suing the state over its gun ban. So an interesting dynamic there. But ultimately, you know, are these cases being consolidated? Is that what happened on Friday? And again, you've got an April 12th hearing that's been set in all four cases, with the state having a consolidated brief due by Thursday, and then a reply by March 16th. Here's Todd Vandermeide.
Here is we have a hybrid of being consolidated and being combined. He said for the purposes of everything, the Barnett case is going to be the lead case that he pins off of, that he works off of. So everything now is going to be listed under Barnett with, you know, the same order being passed along to the other four cases. That puts Paul Clement's law firm in charge of things. And I think that with the divided time, and, you know, we're not all limited to one unified brief. I think it's case management, and we got this kind of hybrid between being consolidated and being combined. I think we are consolidated for the standpoint that oral arguments are going to be a singular set of oral arguments with divided time. And there's going to be one brief by the Attorney General's office for all 4 cases, and we're all going to be heard at the same time. But we still remain a certain amount of individuality between the 4 cases.
So interesting to see that play out on Friday with the federal judge setting the April 12th oral arguments, a March 16th date for the state to reply to Second Amendment allegations, and Thursday the state's supposed to reply to the motion for preliminary injunction from all 4 of these federal cases. That preliminary injunction would impact the entire state, so it wouldn't just be named plaintiffs, which is different than what's going on over in state court. We'll talk about that next. I'm Greg Bishop. It is Springfield's Morning News on 92.7 WMAY, Springfield's News and Talk. You can always follow along with me. Just subscribe, like, follow me on Twitter, where if you followed me on Friday, then you saw the updates as they happen from that federal court hearing. So be sure to make that happen, all right? Again, just search out Bishop on Air, and we can connect that